And I would ask that everyone who's not speaking, please mute themselves. And I'm going to introduce Mike Blake. We had a little trouble with a power outage for our speaker, Adam. He said that he couldn't get his PowerPoints going and he couldn't have access to Zoom. And it just, I don't know what's going on out there. He's on the West Coast. Maybe there's a storm. I'm not sure. So instead, Mike has volunteered to do a presentation on provisional patent applications and give us the pros and cons. I've known Mike for many years. Mike, maybe you'll remember how many years, I don't know. And he does intellectual property law, so that includes trademarks, copyrights, patents, and various legal services that relate to those. So without further ado, Mike, why don't you take it away?
Hi, everybody. I'm Mike Blake, patent attorney in Milford, Connecticut. I'm sharing my screen, so hopefully you guys can see my PowerPoint. I'm in Milford, Connecticut. My website and phone number are there. And today we're going to talk about, as far as how long I known Dave, I think I started coming around IACT around 2004, and Doug, I mean, sorry, not Dave. And I can't remember when I first met Doug. Sometime, I think I first saw him maybe 2007 or so. We started having the meetings at Fairfield U. Prior to that, we're all over the place. We're at Norwalk Library and then the Fairfield Public Library. Anyhow, today we're talking about provisional patent applications, pros and cons. Adam was going to talk about design applications versus provisionals. I'm not really going to cover much about designs, but if anyone has questions, I am a patent attorney, and if you have questions about design patent applications, just raise your hand, and we'll discuss them. But let's just move on with the presentation. So there are four main types of patent applications. The provisional is one, and that's a utility type patent application, which protects the way an invention works. The non-provisional utility, which is the full patent application that also protects how an invention works, but the non-provisional is the one that gets examined by the patent office and will ultimately either issue into a patent or get rejected, finally rejected, and not issued. A design patent application protects the ornamental design of your invention. So as opposed to a utility application, a design protects the way it looks, basically, not the way it works. And then there's a plant patent application that protects plant, like biological plants. And I've never done one. I don't know much about them, but it has something to do with the way you can, I guess, combine different plants. I guess by shaving a part of a plant and putting them together, that's one way to create a new plant. But I don't do those, so I don't know anything about them. So there are pros and cons to provisional patent applications as opposed to a non-provisional. That's basically what we're comparing to. So some of the benefits of a provisional is generally they're lower cost. And I say generally because some patent attorneys really don't give you much of a break on a provisional, because there's kind of a two ways to go about patent applications as far as provisionals. I like to try to limit the time and money I spend preparing a provisional to make a low cost patent application for my clients. So I generally spend about 5 or 6 hours on a provisional, whereas on a non-provisional, it's probably closer to 25 to 30 hours I'm spending. So the costs are a lot less when I do a provisional for my clients, and that's to give them a break so that they can use that provisional year, because a provisional only lasts for a year, and they could do things during that year and not spend all their money on the cost of a patent application, because money's limited for everybody. So for example, I charge $1,800 for a provisional. And for a non-provisional, my floor, the lowest price is $5,000, and I go up from there $7,000, $8,000, $9,000 easily. And so a provisional, I charge low cost. I don't spend much time on patent claims in the provisional. They're not required at all. And so usually what I do is what's called an omnibus claim, just a very short claim that says the invention as disclosed and described within this document. And that's really generally all I do for a provisional claim. The filing fee is lower. For a micro entity, the filing fee is $75. As opposed to a non-provisional, the filing fee is $455 for a micro entity. Micro entities are basically entities, usually people who make less than $203,000 a year and have less than 5 patent applications in their name that they have not assigned to somebody else. If you don't fall within a micro entity category, then you're a small entity probably. And then the fees are basically doubled. So a provisional filing fee is $150 for a small entity. And the non-provisional is $830. And if you're a large entity, which means you have more than 500 employees, then it's double again. So for a provisional for a large entity is $300. That's the filing fee. That's the government fee, not my fee. And then the non-provisional filing fee is $1,820. Another benefit of a provisional is generally you can file those quicker. We don't have to comply with all the rules and requirements for a non-provisional patent application. So we don't need the background section, the abstract, summary of the invention, claims. We don't need to get drawings prepared. Sometimes if necessary, let's say you're a scientist and you prepared a paper and you're going to disclose that paper tomorrow at a big conference, and you just realize, wait a minute, there's patentable subject paper in my paper. Maybe I should file a patent application before I go disclose it in front of 300 scientists. And so that's one reason why a provisional might be very helpful. And we can file that paper as a provisional patent application if we have to. And we can do that very quickly, in an hour or less. I don't recommend normally doing that, but sometimes, to get whatever protection you can, sometimes that's our only option, to file something before you make a public disclosure of your invention. Or maybe you're going to a trade show and you're going to disclose your new whatever it is, a new engine, new tool, and you just realize, wait a minute, before I go to this trade show tomorrow, maybe I should file a patent application. And so a provisional is something you can file quick and relatively cheaply. The next advantage is we don't have to comply with many of the requirements of the USPTO. I talked about that a little bit. We don't need claims. We don't need professional drawings done. There's different sections of the patent application we normally have in a non-provisional, which we don't need in a provisional. And so it can be a shorter document and quicker to prepare. The last benefit on this page is provisionals are secret. So when you file a provisional patent application, they are not published. They are kept secret. If you end up not filing a non-provisional that claims priority to the provisional, then your provisional never gets published. It remains secret at the patent office. So nobody can do a search for your provisional patent application. They can become published or available to people if you file a non-provisional patent application and your non-provisional is published, and then under public pair, which is no longer available. Now they've got something else away, but we can still access the same information under a different search regime. It's not called public pair, I forget what it's called. But the provisional would become available after the publication date of your non-provisional that claims priority to the provisional. But if you file a provisional and then you end up not filing any sort of non-provisional, then your provisional will remain secret and it won't be available to the public. Another benefit of a provisional application is when you file it, then you have 1 year of patent pending status, and you don't have to worry about filing your non-provisional until the 1 year anniversary of your provisional filing date. During that 1 year period, you could, test the market, maybe make and sell your device, try to get licensees for your invention, maybe sell your invention outright to a bigger company. And if you have luck doing that, and you start getting paid for your invention, then it may be a lot easier for you to finance the filing of a non-provisional patent application at the end of that year. Another benefit of a provisional is when you file the non-provisional, if you've made any improvements to your invention during that 1 year period, you can add all those improvements in your non-provisional patent application. The downside of that, though, is your improvements only get the benefit of the filing date of your non-provisional patent application. What that means is if somebody else has already invented that improvement and they filed a patent application before you did, they would get ownership of that improvement based on their filing date of the patent application. Your provisional filing date wouldn't cover you unless your provisional application covered that improvement. But if you made that improvement, let's say you filed your provisional application on September 1st, 2022, and then 6 months later you improve it, you improve that invention because you're tinkering around with it, and then September 1st, 2023, you file your non-provisional, which includes the improvement. Well, that improvement only is protected as of that September 1st, 2023 date. And if somebody else independently invented that improvement and filed a patent application before you on that improvement, they would have superior rights to you. Another benefit of a provisional, just like a non-provisional, when you file the provisional patent application, you have patent pending status. So then you can mark your products and your marketing materials with patent pending, covering your invention. So now we're going to move on to disadvantages of provisional patent applications. And if you guys have any questions, please jump in. So the disadvantage of a provisional is it only protects what is disclosed in the patent application. And that's the same disadvantage that you would have in a non-provisional. But this maybe is more of an issue for a provisional if you're trying to save money, and I'm trying to limit the time I spend on a provisional. So I may only talk about 1 or 2 embodiments of an invention because I'm trying to keep the cost down and spend 5 or 6 hours on it. But if there's 7 or 8 or 10 embodiments that I don't include, they are not protected in your provisional unless I put them in the provisional. And if I put all these embodiments in it, that would drive up the cost. So, so if you're trying to make a very quick and dirty provisional application, it's only going to protect what's in it. And if there's a lot more details that you don't throw in your provisional, those details will not get protected. The USPTO does not examine a provisional patent application, so you won't have any idea whether or not your patent application will be allowed by the patent office because they don't examine it. They just take it and hold it for a year. In a non-provisional, once you file your non-provisional, the patent office will eventually get to it, and they will do a patentability search and then issue an office action unless they allow it. But 90% of the time they issue an office action where they reject all your patent claims, and they're comparing your patent application to what's out there as far as prior art. Or they may allow it. but you don't get any of that indication. You won't get an office action or a notice of allowance for a provisional. They just hold it for a year. And then this last, I'll just read it to you, this last disadvantage. To obtain the benefit of the filing date of a provisional application, the claim subject matter in a later filed non-provisional application must have support in the provisional application. So all that means is if I've added new material to my non-provisional, that new material will not get the benefit of that earlier filing date. The material that was covered in my non-provisional in the provisional will get the benefit of the earlier filing date. Another disadvantage of a provisional is sometimes it sneaks up on people. When you file a provisional or a non-provisional, you have 1 year from that date to file a PCT application that's able to claim priority to your US patent application. So a PCT application is a patent cooperation treaty application. That starts the international protection of your invention. And if you want your international patent applications to have the benefit of your earliest patent application, you have to file a PCT application within 1 year. And sometimes people don't think about that when they're filing their provisional. They're just thinking about trying to save money or get something filed quickly before they make a public disclosure. And they don't realize, well, that starts the clock running on the PCT application. And if I want international protection, I have to file something within 1 year of that provisional patent application. So that can really increase your cost a year later when you're thinking about filing a US non-provisional. Then if you also want to protect it internationally, you also would have to file a PCT at the same time. That's the international patent application. The second point here on this page was investors and others may not take you seriously if you only have a provisional patent application. The clients I work with, I haven't really seen that too often because I think most sophisticated businesses that may want to make a deal with you or invest in you understand that a provisional is a cost-saving measure, and they understand that, and so they take you seriously as they would with a non-provisional that you may file. But sometimes, and I've heard this, not with my clients, but I've heard this anecdotally, is if you're trying to get an investor to invest with you and they find out you've only filed a provisional, they may say, well, wait a minute, you want me to invest several thousands or tens of thousands of dollars in your company, but you've only spent the money on a provisional? So that's kind of the downside there. But it usually doesn't happen as far as my clients have told me. So now we're going to jump to non-provisional patent applications and what some of the benefits are for them as opposed to a provisional. And the non-provisional is the full patent application that you file in the patent office. That's the one that has the claims that will get examined. It has the specification with all the parts that are required, the background section, the summary of the invention, the abstract, the claims, and the drawings if necessary. So a non-provisional application is examined by the patent office, and the patent office will make a determination as to whether or not your invention is patentable. When you file a non-provisional, you can file an international patent application within 1 year that claims priority to it. You can also do that with a provisional also. So that's a benefit of both, I guess. I put it down kind of as a disadvantage because usually when people are filing provisionals, they're trying to save money, and that kind of accelerates the date of the PCT application. If you file a provisional and then a year later, you may have to file both a PCT application and your US patent application. if you skip a non-provisional and go straight, no, if you skip the provisional application and you go straight to filing a non-provisional, your patent application will probably issue sooner because you haven't delayed the whole process by 1 year. Because when you file a provisional, most people wait a year before they file their non-provisional. Well, the patent office doesn't do anything in that 1 year. But when you file that non-provisional, that's when the patent office will officially receive your non-provisional. And that's when it gets put in a line at the patent office to get examined. And so, you know, you'll find out a little sooner if you file a non-provisional first, because you haven't just waited a year, basically. That's what that point is. You get patent pending status with a non-provisional, just like you do with a provisional, and just like you would with a design patent application also. And investors may take you more seriously with a non-provisional patent application because you've maybe have more money in the game. You've invested more by spending the time and the money to file a non-provisional patent application. Some disadvantages of a non-provisional patent application is they are expensive generally, especially compared to a provisional. And they're
I'd like
time
to
consuming.
see it.
Yes. Hey, Laura, do you have a question? Nope. Maybe she accidentally. So yeah, non-provisionals are bigger documents generally, and you have claims for sure in a non-provisional that usually take a lot of time to prepare. And so it takes longer and costs more money to file generally. If you file a non-provisional, you may get a negative office action early. You may get a rejection real quick, and that could screw up your marketing plans. And you may be thinking, oh, I have 2 or 3 years to market as patent pending. And if you get if you file a non-provisional, it's possible you might get an office action within 6 months that rejects it. And then you're like, what do I do now? You can respond to that rejection. And usually once you get a first office action, the second office action will be a lot quicker. Sometimes when you file a non-provisional, you may not hear from the patent office for 2 years. But then once you get that first office action 2 years later, and you file a response to that office action, generally you'll hear back from the patent office with a second office action a lot quicker than 2 years. Usually it's just a few months. So you may receive a negative office action very early, and therefore a final office action very early. And if you get a final office action that you can't really get around, then basically it's your patent application will become a non-entity. You will no longer have patent pending at some point unless you respond to that final office action. And if you're not patent pending anymore, that could change your whole marketing. If you're planning on saying patent pending for your product that you're trying to sell.
I got a quick question. Could you explain in a few words how final a final office action is? Because I got final office actions and they weren't final.
Yeah, final office actions generally just means that the patent office has issued 2 office actions with respect to your patent application. And more specifically, they've issued 2 office actions with respect to your filing fee. Generally, you only get 2 office actions for 1 filing fee. So if you get a final office action, you can file several things. You can file a continuation patent application, which means basically it's the same patent. Maybe you've changed the claims, but you file another filing fee. So that would be, if you're a micro entity, another $455. And then the patent office will happily issue another office action after the final, once they get their filing fee. Or you can file what's called the request for continued prosecution, which will generally keep it in front of the same examiner, and you don't file a new patent application, but you do file an RCP fee, which is pretty much the same as a filing fee. And so The patent office just wants their fees. And so you can file almost unlimited numbers of continuations and RC requests for continued prosecutions.
So I got a follow-on question. What are you able to guide the patent office so that your patent is reviewed by the correct directorate within the patent office system?
You can, if you use the right terminology. There's certain words, if you want to get in front of a certain group, the patent office is divided by groups and they have a group number. And so if your title, let's say, is for a new type of basketball hoop, that would go in front of a certain group. But if your title is something like a software for designing a basketball hoop, that would probably go in front of a software group. And it also might have to do with the claim language you use too. I've never spent a lot of time trying to get in front of a particular group, but some patent attorneys do. They try to keep in front of a certain group that they like, and so they know what terms to use to get it in front of that group. Okay, hopefully that answered your question, Doug. So I've got a little slide here of if you're trying to decide between a provisional and non-provisional, how can you decide? And so these questions hopefully can kind of guide you. Do you need to delay cost? So between a provisional and non-provisional, a provisional is probably the way to go to delay cost. So if you don't have much money up front, then maybe file a provisional, which is cheaper generally, and that gives you a year to either get investors or maybe sell some product to get money in. And so if you want to delay costs, file a provisional. Do you want to save the total output of money? Then you would file a non-provisional, because if you file a provisional for $1,800, let's say that's what I charge, then a non-provisional is going to cost at least $5,000. There's no discount, at least I give, for if you file a provisional first and then we file a non-provisional. I don't take $1,800 off the provisional. The reason is almost always, 99% of the time, there's been a lot of changes to the invention during that 1 year period. So, I'm basically billing for my time. And so it's going to cost you at least $5,000 for the non-provisional. If you skip the provisional, then you saved yourself the $1,800, for instance, assuming you went with me or any other attorney. If they will charge you to file a provisional, so you could save that money and go straight to the non-provisional. If you're aware of infringers that are out there infringing your invention that you haven't filed a patent application on, then you want to file a non-provisional first in order to get that patent application to issue as soon as possible. Because if you file a provisional and you wait a year, that delays a year before you can sue anybody for patent infringement. So let me take a step back. You can't sue anybody for patent infringement with a patent application or just an invention. You have to have an issued patent before you can sue anybody for patent infringement. Okay. And if you file a provisional first and you wait a year and then you file your non-provisional, then you've delayed the time to get a issued patent by a whole year. And if you want to start suing people for infringement as soon as possible, you want to file a non-provisional. And there's also another, you request accelerated examination. And if you pay an additional fee up front, then the patent office will give you a final determination on your patent within 1 year. And so if you know there's infringers out there, you may want to do that. That's it. So let me go back here. Are there any questions? I know I threw a lot at you. I didn't really talk about design patents. And I know that's Adam was going to talk mainly about design patents, but I'd be happy to answer questions about those or anything else.
Mike, this is Joe Goldberg. I just want to add something from experience. I guess it's a comment. And you don't really get the swing from lawyers. It's more an inventor's thing. But the provisional patents are a lot easier, less formal, and have a branding to them that really is helpful. I've submitted provisional patents that are nothing more than a good PowerPoint. And, got some pictures and then usually just rather than put in claims, I make lists in one of the charts of things that I think is important that may evolve to claims. But you can put it in and it makes a world of difference. Not so much with your investors, but when you go talk to other people like suppliers and people you want to help to say you've already protected what you've gotten for a year with a provisional. And, it just put you on a different conversation. And I do want to emphasize, I've included hand sketches, things I've done on tabletops and taken photographs of them. So they really provide you an easy way to get some protection for a year. And a year's, time when you can evolve a lot of things and talking to people. So I think you need to get that flavor about provisional patents. That's important to inventors.
Thanks, Joseph. And I generally agree. But one thing about when you file a provisional, especially if you do it as a layperson, the one main thing you got to do to get any protection, because you could file paperwork with the patent office and it may not protect you at all. So what you file has to be enabled. So the invention that you're talking about in your provisional patent application, a person of ordinary skill in the art who reads your provisional patent application and looks at the drawings, if there are any, has to be able to practice the invention by simply reading your documents and looking at the drawings if you have any. If he's unable to do that, then you really haven't protected yourself at all. So you're right, it's a lot easier than a non-provisional, but there are certain minimum requirements. And the main one, I believe, is your invention has to be enabled. So there has to be enough details so that a person of ordinary skill in the art can read it and build or practice your invention by reading that provisional patent application. So when you talked about lists and stuff, that made me worried. So you could have a list of, let's say, benefits, but if you don't talk about how you can make and build this invention, then there's a good chance you really haven't protected yourself.
Well, I would only comment that that's true, and you may have a crummy provisional, but it gives you a year with saying patent pending, and you can work. And you can feel comfortable talking to people who even you would not normally talk to because you think they might steal something, or, and especially if you think it's unique and you want to have something to claim it's yours.
No, I hear you,
So,
Joseph.
yeah.
But the problem I'm worried about, and I'm a lawyer, so I always think of the worst case scenario is you may think you're protected, but if an objective person reads that provisional, and I'm sure you're a very smart guy, Joseph, and you write well and you get your ideas across on paper, but there's a lot of lay people who have a hard time getting their ideas across on paper. And when you read their provisionals that they've prepared themselves, I've read some that just you can't figure out what they're doing, and they may think they're protected, but they're not. So
I'll let it go with that. But most times when you do a provisional, it's because your idea is still working out in your mind and you just want some protection. It's really not a matter of, can you make it? You're just letting the year go by and see what evolves. And then if you've got something, you go to a non-provisional or you let it drop and move on.
yeah, I hear you, Joseph.
So
other-
that's my comment. Just thought I'd throw that in.
Yeah, thank you.
Yep.
Any other questions or comments?
So I have a question. If you're not seeking PCT type protection, and do you still get a year if you publish something in a paper?
So if you publish something and you don't file any sort of patent application, is that what you're saying?
Yeah, yeah.
So for international filings, most countries require absolute novelty. So that means if you make a public disclosure of your invention without filing a patent application first, you lose the right to file in many countries in the world.
But not this country, right?
The US has a 1-year grace period. So if you publish in the US, you have 1 year to file a US patent application. But if you published your paper and then you filed a PCT, you're basically wasting your money because most countries have absolute novelty. You have to keep your
I get it. Publication is a positive barrier to patentability for PCT. But if you're just going to file in this country, you got yourself a year. But now we're a first to file country. So how has that impacted this practice of publishing something in order to claim priority?
What is a PCT?
That's the Paris Convention Treaty, I think, isn't it?
It's not Paris. It's is it Paris?
Patent. I think it's
Patent Cooperation Treaty. Yeah, you got me confused. Patent Cooperation Treaty.
Okay.
PCT. So that's an international patent application that starts the process of protecting your invention in foreign countries other than the US. I forgot your question, Doug. What was your question?
So yeah, what happened prior to first to file?
Oh.
It was first to invent. Now we're on a first to file system, and I'm still worried that I don't have the ability to just claim priority since I published first, since someone else can file first.
So in the US, if you published first, then that publication of yours cannot be used against you as prior art if you file a patent application within 1 year. If a third party sees your paper and files a patent application on that same subject matter that's in your paper, that paper can be used as prior art against him or her to invalidate or to reject his patent application.
I see.
That's one thing. The other thing is if somebody else gets the idea for the invention or gets the invention from your disclosure, he can't really file a patent application on something he got from you. But that would take some sort of, you'd have to file some sort of inter partes action at the patent office to prove that somebody got the idea from you and then filed a patent application on it.
If I look confused, it's just because I'm thinking.
Well, it's I didn't explain it exactly completely 100% right, but you're not allowed to file a patent application if you got the idea from somebody else because you're not the inventor.
You have to be the actual inventor.
Yeah. But it's possible your paper was published and somebody independently invented it. And if they file first, they would have priority over you. If you filed second, except your paper would still be prior art that can invalidate or reject their patent application. But
And it depends when they file.
yeah, if they filed after you published, but before you filed, they would have priority over you, except your own paper could be used against them to reject their patent application.
So
can't
not
be
to
used
put
against them.
too fine a point on it, Mike, but when I publish a paper, I submit it, and then there are these people, and they review it, and they do not sign a non-disclosure agreement. So now these reviewers could turn around and say, "What a great idea! I'm going to go file it before this thing even hits the press."
Yeah, and then you could file some sort of inter partes procedure at the patent office saying, they got that idea from me. I submitted a paper to this guy, Dr. X at Fairfield University, and I can prove it. And that would go before the USPTO office. And if you could prove it, you could get their patent application invalidated. Or if the patent issues, it would be invalidated.
Cool. Thank you.
Yeah, for what it's worth, I filed a provisional some years back. I was working on something and someone pointed out a patent to me that was rather important to a manufacturer. And I looked at it and I said, I know how to get around that patent with something that is totally novel. And I knew exactly who I wanted to license it to. So I got a provisional, disclosed it to them, and it just didn't fit their circumstances to pursue it. And I let the provisional go, but it was a cheap way of protecting myself. So the provisional was useful that way. And what I did is I took the patent that I was getting around, and I copied it, edited it totally for my purposes, disclosed and referred to that in my editing, and it was terrific. But hey, I didn't get anything out of it, so.
And that's a great reason why to use a provisional right there. Another cheap way to protect yourself, and if you filed your own provisional, you spent some time, I guess, a few hours, I imagine, plus the filing fee. But another way to do it is get them to sign a non-disclosure agreement, which could be save you a lot of time.
We did do the non-disclosure, and largely what I disclosed, what was in the provisional.
Yeah.
Well,
And
all right.
I had to do that work anyhow, so it all worked out, except it never went anywhere.
That's
Question.
probably the case with 90% of all patents. Probably don't go much further than just the patent application. They may get an issued patent, but probably 90% of them don't make any money.
Understood.
Is copyright another avenue to protect the patent since he wrote the paper and published it?
So copyright protects creative works. And I guess you can make the argument that the specification and the drawings that you've created are creative works, but the consensus that I've seen is when you file something with the patent office, the actual document itself and the words and the drawings are not really protected by copyright anymore. You can't assert a copyright against somebody who copied your drawings and used them, for instance, in another patent application. That's kind of the same thing when people try to do that with civil litigation, when you filed complaints and motions and stuff. For a little while there, lawyers were putting down copyright notices at the bottom of their papers, but the same rule applies for court documents. They become public domain, basically. And lawyers are well known for copying and pasting other lawyers' motions and complaints and stuff. And there's no real copyright that's ever been won in that type of case, or as far as I know, any sort of patent documents that have been copied. There's never been any copyright victory for a copyright owner.
So in other words, you need to copyright a pre-patent application and start the creative protection upon when you've, I guess, in other words, is that another road to protecting your idea in
No,
totality?
so a copyright on your document, let's say you describe your invention in a written document and you're depending on copyright to protect you. That only protects you from other people making a copy of that document. But someone can read that document and build the invention, and he's not infringing your copyright. He only infringes your copyright if he copies your document. Okay, if he reads your document and paraphrases it in writing, and he's not infringing your copyright in that case either. So if you have an invention, copyright generally is not going to give you much protection. If you have a software code that you've written out, then copyright will protect the code, but someone can rewrite the code in his own and paraphrase the code, and he would not infringe your copyright. Does that make sense?
It does. Thank you very much.
All right, then. Well, I want to thank you, Mike. That was a great presentation. Maybe everyone can join me in thanking the speaker. Sorry, we didn't have the scheduled speaker come. I guess we couldn't help it. He had a blackout. In case you're tuning in late and you got disappointed. And Mike has very graciously volunteered to do the presentation today. So thanks again, Mike, and I'll see you guys all next time. Bye-bye.